Hello and welcome to Williams Mullen's Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host today, Courtney Reigel, and I will be joined by Janet Cho, a partner in our intellectual property practice group here at Williams Mullen. In today's podcast, we'll be covering recent fee changes at the United States Patent and Trademark Office, or USPTO, and some implications of the same. Janet, thank you for joining me today. I was hoping that you wouldn't mind kicking us off with an overview of those new USPTO fees that went into effect at the beginning of the year.
Yes, happy to, Courtney. Thank you for the introduction. And this is, I will say, a very important topic, although maybe it's not the most fascinating topic. It's not the one that gets headlines, but I think it's really, really important just from a practical perspective and also for long-term brand management considerations. So at the beginning of this year, there were some new fees imposed by the USPTO, or sometimes I call it the office. I'll use those terms interchangeably here for our listeners. So those who've been filing applications for a while may recall there were different types of fees depending on the type of application you filed. Terms such as T's, T's plus, things like that incur different fees. So now with the fee changes, the fee schedule is in some ways more simplified, but I think the upshot is if you're not strategic about how you file your applications, you might subject yourself to fees that you hadn't anticipated, and the fees can rise very quickly. So on a basic level, the change is this. If you file an application, you will be levied a $350 fee per class of goods or services claimed. After that, whether or not you are levied additional fees really depends on what goods and services you claim in your application. So for those who don't know, the USPTO maintains this database called the Acceptable Identifications Manual, or what we everyday trademark people call the ID manual. And I believe lots of trademark offices and registrars around the world have such a database or have such a repository, and it's really an elaboration of acceptable or previously accepted or not, non-offensive rule comporting descriptions. And sometimes they are, portions of a description, sometimes they are descriptions in whole. So if you file an application in one class and your entire description comes from that ID manual, then your fees will remain at $350. And that's the end of the story. If you file in two classes with descriptions taken from the identification manual, then it will be $350 times two, or however many classes you end up including in your application, provided that you take all of your description from the ID manual. So that's one side, and I think that's pretty straightforward, and it's a relatively efficient calculation. The big change is that the USPTO now levies additional fees for what is called free form, and that is if your identification does not come from the manual or any portion of your description does not come from the manual. So if you are a party looking to file an application with what I might term a bespoke description, or any part of it is bespoke, and I think for those familiar with the ID manual, very often you might see a description such as financial services, namely, and there's a blank where you as the applicant are to fill that in, that portion of the description would be considered free form. So if your entire description or a portion of your description is not in the manual, you will be levied an additional $200, what I like to call the upcharge. And I know that's probably something taken from another sector of our economy, but it really is an upcharge. So if you are in one class and you are including a description that's not from the manual, you will be charged $350 for just the basic act of filing an application, plus the $200 upcharge. So it's $550. So if you're not taking a description from the manual, your fees will rise $200. And the wrinkle in this, and one thing that I really want to emphasize to the listener, is that, or our listeners, is that, well, you might think, okay, that's great. I typically file 2 class applications. My class 9 description is always taken from the manual. My class 36 description generally is a bespoke description that really reflects the nature of our business. So I'm only going to be charged the $200 upcharge once for my bespoke description. The wrinkle here is that if you are charged that upcharge for one class, you're charged in all classes, even if the other classes are taken from the manual. So it's an all or nothing proposition. So you can't really get around or defeat the $200 additional charge by keeping some descriptions in from the manual and keeping others from outside of the manual. So that's why I say it's something to think about. And I know many of our listeners have probably filed every single application using the same description, and you haven't been challenged on the description, at least during examination of the application. And that may still be the case, but at the same time, you may still be levied that additional fee. So I want to be clear that what we're talking about is just the fee side of it, whether or not your description is in the manual for the sake of fees. Your description may not be in the manual, but it may be something that's substantively accepted by the examining attorney, meaning it may not be subject to any further clarification or requirements for amendments. So that's one big change. The other big change is there's this excess character fee charge as well. So the way that that works is in a description per class, you are entitled to have the first 1,000 characters as part of your fee, whatever that may be, whether it is the basic $350 fee or also inclusive of the $200 upcharge. But any characters after that initial 1,000 will be levied a $200 excess character fee. And that count includes everything. It includes, spaces, it includes punctuation, it includes text, everything is included. And for every 1,000 after the initial 1,000, you will be levied that $200 fee. So depending on what you want to file for or what you typically file for, your fees can rise very, very quickly. And I will also say these are very, very recent fee changes. Quasi recently, which I think a lot of our users, our listeners will remember, is that not too long ago, there was also the fee change relating to office actions, where typically if you had an office action, you had 6 months to respond, and short of your issue specifically requiring additional fees, you didn't have to pay additional fees. One fee that has been incorporated into the application stage or the prosecution stage is that you still have that 6-month time period to respond to an office action, but now the change is that you have to, at the 3-month period, you can either respond substantively to the office action or pay a fee to extend. You still get 6 months to respond in total, but in order to get to that 6 months, you have to extend that time period at the 3-month mark, and that's for a fee of $125. So I'm throwing out a lot of numbers and a lot of timelines, but it's really just to say that these are new fees and sometimes deadlines to be aware of, and just to start thinking more about the strategy for your application filing. And one thing that they have gotten rid of, as I said, is they've gotten rid of the T's and the T's plus applications. Those are no longer in play. It's really all about whether or not your goods and services descriptions are taken from the manual.
Yeah, thanks, Janet, for the overview of the fees. I think this is so helpful for listeners to hear because it really does impact the overall budget for new trademark applications, the prosecution process, because it also includes the additional fees for extending office action deadlines. And I just wanted to also add in that there's this additional fees category where there can also be a $100 fee added where certain information has been left out of an initial application and an examiner requests additional information finding that it was insufficient at the time. Previously, that was just requested by the USPTO and you could provide it without a fee, and now there will be a fee to accompany that. And so to kind of move forward on talking about how the fees might implicate or make changes with how we recommend that clients file new trademark applications and how attorneys can kind of guide them through that process. For some strategies, Janet mentioned the ID manual. This is something that you can access publicly that we regularly use to see what descriptions of goods and services have already been approved by the USPTO. And if something is not actually included in the manual, you can request that it be reviewed and added. That's just an email address that you can find and send to the USPTO. So suggest considering and doing that for descriptions that have not been already included. This might be particularly relevant for, as Janet mentioned, clients that have used the same description historically and have never had issues with the USPTO saying that it's not acceptable, but it might not be in the ID manual. And so now might be a good time to consider having it added so that you will not have the additional freeform fee in the future. This might also be something that you consider for clients with a new or unique product that isn't yet in the manual. You might consider trying to add that description to the manual now so that later their applications will be at the lower fee. And this can, of course, be more important for trademark applicants who might have multiple marks that they're interested in filing to protect, or that have a lot of different classes that they are filing in, because, as Janet mentioned, that additional free form fee will apply to every single class that you add in one application. So it might also be worthwhile to consider whether you might file multiple applications in single classes versus lumping those all together in one application, because you may be able to actually have reduced fees by kind of carving out just the descriptions that need the free form additional fee and including those separately. And then also just being more strategic in how we describe those goods and services in the applications, making sure that we are not using excess characters or kind of repetitive descriptions. That wasn't a concern in the past. So I think it's pretty common that you'll see some descriptions where there's a bit of the same words repeated. Just being strategic about how we can use a limited amount of characters to describe the same products and services, and just overall planning ahead with budget and kind of managing client expectations on what the new fees at the USPTO mean for kind of their trademark applications and the prosecution process moving forward. Janet, I'll get it back to you with anything else to add.
No, thank you, Courtney, very much. And I will say we have touched on just some of the fees. We could go on and on about some of the fees. There, over the past few years, not all of them have arisen in 2025, but over the past few years, there have been fees that have arisen all throughout the life of an application. We're just talking about right now at the very genesis, which puts some control back in the hands of the applicant so that you can think ahead. And I think it's very easy to not notice the $200 upcharge at the very beginning, or if your application has two classes, or you're just filing one application maybe every year or something like that. It might not be material to your budget, or it may not be something very discernible. But once the prosecution of the application starts to proceed, or you have more than one application in a year or a 6-month period, and you want all of those descriptions to be somewhat more tailored, then I think the fees will likely be you can probably feel it very quickly. So we would just emphasize that to put more control of the process in the applicant's hands is just to think ahead a little bit. And I think if our listeners weren't accustomed or familiar with the ID manual, I think it's going to become everyone's best friend. And it's free to add things to the manual. And even if you don't end up using that description, you've added to the repository, and maybe you'll use it later, because goods and services descriptions are not proprietary. So we hope that all of this information is helpful in terms of the way forward and putting some control back in the hands of applicants so that they can make the best decisions for the applicants themselves, and giving you some wisdom on how to best manage the fee landscape. So thanks, Courtney. I believe that will wrap up our discussion on trademark fees and this episode of Trending Now, an IP podcast. We look forward to keeping listeners up to date with all of the changes in this field. and any other updates that might be relevant to our listeners. Listeners, if you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next update posts. Thank you for listening, and until next time.
This podcast contains general, condensed summaries of actual legal matters, statutes, and opinions for informational and educational purposes only. It is not meant to be and should not be construed as legal advice. Listeners with particular needs on specific issues should retain the services of competent counsel. For more information, please visit our website at www.williamsmullen.com or contact any member of our team.